Hello, everyone, and welcome to another episode of Give Me Some Truth International Edition. I'm Sil Michelin, and I'm joined today by Keith Poniwaz and Stan Farmer. And in addition, we are thrilled to have a special guest on the show today. David Luzon from Barclay Damon is joining us on the podcast. So thanks a lot, David, for being part of this episode. We're thrilled to have you. And our cheerful, exciting topic.
I'm pumped.
Yeah, I know. Stan's really excited.
Well, actually, though I feel like this is kind of the question that you're likely to get asked at the proverbial cocktail party, right?
So the cocktail party question, this is our topic for today, is what happens if I die abroad?
You and I go to different parties if this comes up.
So, and it only seems fair that we cover this topic. I mean, we spend a lot of time on the podcast talking about taxes, so we needed a day to cover the other certainty of life, right? Only two certainties, death and taxes. So today we're going to talk about what happens if I die abroad. And all jokes aside, I mean, this is an important topic for people in the expat community who, decide to move abroad and relocate and have to think about the implications of that long term in terms of, estate planning, inheritance, probate, right? So what happens when you're in a situation where maybe your assets are in a particular country, but maybe you live abroad and maybe you have assets in different part of the world, right? So,
and what we should be clear is, so the reason David is joining us is not because he's an undertaker. We're not dealing with that part of what happens if I die abroad, the relocating of the body. That you're going to have to go to a different podcast for that.
Yeah, and actually it's funny because David reminded me yesterday, he was quite right, that we should make sure the podcast is also useful for people who are alive, and we are going to talk about the planning aspect, right? What can you do to prepare for the eventuality that something may happen to you while you're abroad. So again, David, thanks again for joining. And maybe just to kick us off, you can tell us a little bit about you and your practice and your firm for people who may not be familiar with your work.
Sure. Thanks so much, gentlemen. Really appreciate the opportunity to chat with you this morning. You know my name, it's David Luzon. I've been a trust and estate practicing attorney for over 25 years now. I'm an equity partner at my firm, Barclay Damon. We are a large Northeast regional firm in the U.S. We have approximately 300 attorneys now and 200 staff, with offices from New York City, in downtown Manhattan, Albany, Syracuse, Rochester, Buffalo, Toronto, Ontario, Canada, Boston, Massachusetts, Washington, D.C., and in Connecticut. So we're kind of that large Northeast regional presence in the U.S. Having said that, we work with clients all over the world, and particularly in this area of trust and estate planning and administration, and also in tax advising. So that's a little bit about me. I've been working with people from all over the world on their planning and administration for quite a number of years. So I've learned a lot, which has been great, that I can pass on to clients. And I've seen a lot of different situations when people do die abroad and then need to deal with the problems or situations, fact patterns in the U.S., what the requirements are, and in the countries where they passed away, whether they were domiciled there, resident there, etc. So that's a little bit about me. And
I think to just sort of clarify again for people tuning in, we're not talking about what happens if you die on vacation abroad. So you mentioned two terms, resident and domicile, and those are, I would say, frequently governed by local law and local rules. But could you talk a little bit broadly about those two terms and what they might mean and their importance for people, who live abroad?
Absolutely. So let's add a third to that. So we really need, when we're talking about either dying abroad or being an expat with assets here in the US or assets around the world, we need to talk about citizenship, residency, and domicile. So citizenship is relatively clear, right? Most people know and can just say off the cuff where they're a citizen of, right? Or if they're dual citizens, which countries they're citizens of. And then we have residency, right? One can have many residences. We have clients that have residences all around the world. But then there's this other concept of domicile. Even though you can have multiple residences and multiple citizenships, you really only have one domicile. And the domicile concept is really where you intend to stay or return. So you could live in the US for a number of years and not be domiciled here. If your heart really lies in the UK, you're here living here for a number of years on a work assignment or for other reasons, but you always intended to go back to the UK. So domicile can be a bit tricky, but it's an important concept here because the United States taxes its citizens, right? No matter where they are in the world, where it doesn't matter. Taxes on citizenship, but other countries tax on domicile and sometimes residency. To make it even worse, we're not going to go down a rabbit hole, but there are lots of different taxes in the U.S. There's income tax, estate tax, gift tax, generation skipping transfer tax, and the domicile rules apply to the estate tax and gift tax, but they don't necessarily apply to the income tax in the U.S. That's governed by residency. So you need great advisors like these three gentlemen to help you through certainly all the income tax issues. We can help with that too. And I can help on the estate tax side and gift tax side and generation skipping transfer tax.
And you're right. Yeah, absolutely. I think it's important to highlight then this concept of domicile because that drives a lot of things. Obviously, tax is one component, but also it affects things that have to do with probate and how that works and the distribution of your assets, et cetera, et cetera. So one conversation that we have with a lot of clients or prospective clients kind of goes something like this. So usually a typical expat scenario would be someone who maybe moved abroad for retirement or as part of a work assignment or just a lifestyle change. And they end up relocating permanently and their lives just gravitate away from the US and they are fully settled in their new countries of residence, right? But maybe their estate plan, like their will, for example, is still established in the US. Maybe it was established prior to relocating, and maybe it was established a very long time ago, right? So that's a pretty typical scenario, and I would bet that a number of our listeners right now are in that exact scenario, that they drafted a will 20 years ago in some U.S. state, maybe after they got married or after they had their first kid, and they've never updated it, and they now live in Germany, Portugal, Japan. So obviously you're not going to, solve everyone's estate planning issues right on this call. And these questions are always very difficult and they're very case by case. But what are some of the kind of the potential issues, the red flags, the things that you need to be careful with or aware of if you are in the kind of situation that I just described? What are some of the areas of complexity that people may not have considered?
Great question. I think the first thing I could say on the topic is don't assume that your will is going to work, given where you've landed in the world. The laws of the country where you reside or where you're now domiciled, really, in your description, are going to govern how your property passes after your death. And that those laws and rules and the way your property is going to pass may be quite surprising to you. And unless you've really boned up on the law of the country where you are, there's a big distinction between common law countries like the U.S., where we use wills and trusts all the time, and civil law countries. And we could go down a big rabbit hole there too, but we're not going to. And civil law countries generally have forced inheritance, and the law determines who your property goes to, despite what your will says back here in the U.S. So, don't assume that your will is going to govern your property if you're domiciled somewhere else in the world. It may or may not, depending on the laws where you are. And that's certainly something that people would want to investigate. Since if you retain your U.S. citizenship, you will always be subject to U.S. estate tax and income tax laws. And so if you are a U.S. citizen residing somewhere else or domiciled somewhere else, you definitely want to coordinate with a U.S. estate planning attorney and an estate planning attorney in the country where you are.
So, David, as well, in terms of this coordination, people have all sorts of assets. We might say they have real assets, houses, cars, that sort of thing. And they might have bank accounts, and they may have bank accounts in the country where they live, and they have bank accounts here in the U.S., or they might have brokerage accounts here in the U.S., IRAs. Can you talk a little bit about the differences between kind of real property and how that works, and accounts, we might say, more, intangible assets,
movable assets,
and then we probably have some follow-up questions for you from there.
Sure. And feel free to jump in if I'm not covering something that you guys have experienced, because you guys have experienced a lot on the security side and the beneficiary designation side. So on the real property side, right, real property is generally governed by the country's laws where it sits. And so if you're out of the country and you have a real property here in the U.S., right, U.S. law, state law, where the property is, and federal law as far as taxing it, are going to govern how that property passes. However, if you have property in the country where you're residing, right, that country's laws are going to apply to that piece of real property. For U.S. citizens, like I said before, federal law in the U.S. is going to tax all of that property, no matter how it's being passed by beneficiary designation or transfer on death, etc. But there may be some conflicts between the laws of the country where you're domiciled and the laws of the U.S. That might cause problems with passing assets by beneficiary designation or transfer on death designation.
Right. So, David, I mean that has been an area of concern. A lot of clients and potential clients are, under the assumption sometimes that if they keep a U.S. address on their accounts, that somehow their transfer on death instructions are going to be honored regardless of where they die when the time comes, and of course we try to dissuade people of that idea. In fact, it can vary by financial institution, but we found that in most cases transfer on death instructions are not allowed if you have a foreign address, but if you keep a U.S. address, that kind of makes it worse, right? I mean, in the sense that there's nothing worse than the false sense of hope that your estate plan is going to work when it's in fact doomed from inception, right?
That's for sure. Yeah. So on the TOD, I mean, I'm assuming that it's similar to having I know what a TOD is, but for discussion purposes here, right? a TOD is intended to pass to the person that's named, right, as the beneficiary, similar by operation of law, right? Instead of going through a will or the probate process or anything else, on a TOD, typical, designation, the person that's designated would automatically get the property, similar to a joint holding something jointly, where it doesn't have to be probated, automatically passes to the person that's a joint holder on the account or on the deed. What we find many times, and we work with a lot of clients are in the situation, U.S. citizens particularly assume that if they have a TOD designation or a joint designation or a beneficiary designation, that even if they die outside the country, right, those are automatically going to be honored. And there's a huge tax issue that comes up, and a transfer certificate is needed in order to get the company to actually make that transfer. The tax reason behind that is that if there's a tax law and a regulation that says that the person or company in possession of the asset is personally responsible for the estate tax that might be due out of that pot of money, if they transfer it without a U.S. executor being appointed, or they get clearance from the IRS in the form of a transfer certificate. So we have handled a number of situations. I've got one going now. Decedent and his wife moved back to Canada. He was a dual citizen. She was not. Didn't matter what her citizenship was. And she had a $2 million, he had a $2 million IRA payable to her directly on the beneficiary designation, which would have worked had they stayed in Florida where they were. But they moved back to Canada because he was sick and they wanted to be near family. And they were shocked when they applied for the payment of the IRA over to the surviving spouse. And we're told that they need a transfer certificate. They had missed the filing deadline, so there were all kinds of issues there that we were able to help with. But I would say another, thing that people need to think about is don't assume not only that your will's not going to work, but don't assume that just because you have these designations on assets in the U.S., that they're just going to be passed to that beneficiary right away.
And that's key. I think that's a very important point because, the main concern for a lot of people abroad is if something happens to me, how can I make sure that my beneficiaries get access to the funds quickly? Right. And that this doesn't turn into a, convoluted 2-3 year type process. And then that there's all sorts of issues that go along with that, cash flow issues. So, it is true that, so you brought up the validity of the will, that's key, but a lot of people who keep assets in a different country will try to find a will substitute, right? They'll try to make arrangements so that the will doesn't even come into play and their assets can be transferred by act of law. And David brings up a very important point in terms of the custodian of the assets in the U.S. being if I understand correctly, a de facto executor and potentially liable for estate taxes that are not paid. So what happens in practice is you may find yourself in a situation where, as you try to have a beneficiary designation or a joint account designation, you try to rely on that designation to transfer the assets to a beneficiary, you will be told, hang on, it's not that simple. There is another hoop that you need to jump through. There is an additional process that you need to work on, and that's obtaining that transfer certificate. So, David, can you explain what the transfer certificate is and how you go about getting one, and how long does it take to get one?
Right. Yes. Well, the last question being the key, right? Being the most important. But we'll start from the top. The application for a transfer certificate is not that difficult, frankly. But it does require gathering a bunch of information and having the surviving spouse or the nominated executor or someone, fill out an affidavit that we prepare, basically, stating to the U.S. government the U.S. assets, the worldwide assets, trying to determine, whether or not there's any estate tax due, and then submitting that to the IRS, sometimes with copies of appraisals if there's U.S. property and other supporting documents, and then waiting for the IRS to get back to us with that transfer certificate. And when we get a transfer certificate, we actually get a physical piece of paper from the IRS that has a listing of the assets that we're looking to clear from estate tax, so that then we can take that to the custodian of the assets and prove to them that there's no estate tax due, and they should honor the beneficiary designation and go ahead and transfer the asset. The IRS is wildly all over the map with regard to response time. Shockingly, I received one back within 60 days recently. I mean, that was a huge success. I mean, practically wasn't even on our tickler list yet, and we got it. I've been waiting over a year now for at least two of them. So the IRS is saying 9 months to a year as far as its kind of estimation of where they are on response time on these. But it is kind of all over the road. I think if it's a very direct, very simple application with not a lot of assets, the response time is pretty good. But otherwise, you're 9 months to a year and a half on waiting.
So if I am thinking about this and I want to avoid the process of a transfer certificate, is there anything I can do? Or are there any kind of helpful tips to speed up this process?
So there's something that can be done. Sometimes I don't know if it's any better. It might not be even as desirable as just waiting for the transfer certificate. You can have a U.S. executor appointed. That'll transfer the liability from the company to the U.S. executor, but then that executor is going to be involved in estate administration. The process of probating a will or getting an administrator appointed if there is no will in some state in the U.S., which state that is, if this person is no longer domiciled here, is a question, but that can be sorted out. And then they're in the estate administration process, which may not be difficult. There may not be anything to administer. You may be just getting a U.S. executor appointed so that you can avoid the transfer certificate. But you may have to wait to close up the U.S. estate for a statutory period, depending on what state you get appointed in. So we can certainly do that. Other than that, unless they're going to use other assets to benefit their beneficiaries, like life insurance or something else that might be more readily payable, there's not a lot that can be done.
Yeah, no, I think, though, it is kind of a good reminder that usually in a lot of cases where this often gets difficult is a couple, one spouse points the other the executor, and they're both living abroad and they don't think about it, right? And that particularly if you have children living in the United States, that frequently seems a natural place to have an executor, but you raise the excellent issue of which state it gets executed in and so on and so forth, and how you take it from there, and whether you need to file the will, and each state has different rules and regulations and how they treat wills and probate and all of that. And so it really gets down to, in a lot of cases, you have to take it based on the specifics of the case itself.
And so if I can bring this back for a minute to the planning side, I know we're talking about what happens if I die abroad, and we're seeing all these issues, right? We're kind of laying them all out. Those are all the things that we would consider on the planning side to help alleviate some of this, right? To get a proper plan in place.
Absolutely, because, and I think a question we get a lot is, okay, as part of this planning, what's the right strategy? Should I have one will? Should I have two wills? Should I have a will in my country of domicile? Should I have a will in the US because I still hold the bulk of my financial assets there? And, there's no,
Well, beyond that,
Well, the answer is it depends.
Exactly, right?
yeah.
Horrible attorney answer. I know.
No, and that's the only answer. I was going to say, there's no obvious answer.
Beyond that, it seems to me that the liquidity concerns challenge the traditional patriarchy idea of, well, I own the assets, but I'm taking care of, my wife is taken care of, my children are taken care of, and so on. If everything stays in my ownership, or this traditional, we'll have an account that is jointly held. That could create a problem under this scenario. That seems to me, from a planning standpoint, it might behoove people sometimes to consider the idea that that both spouses might benefit. There might be some benefit to both spouses having accounts, so that they know that no matter who dies first, because that's something we don't know, right? We don't get to pick the order. And if one spouse dies first, this is kind of a way to assure that the other one isn't going to starve waiting for a transfer certificate or
Right.
state probate. Or
It is so important.
Absolutely.
It's unbelievable because, a decedent, the first decedent's estate could be tied up for 6 months to a year. I mean, it's horrible to think about, but there could be a huge liquidity issue there. And so you're right, having some balanced assets in each spouse's name that each has access to is pretty critically important.
Yeah,
Right.
and then on top of all of these U.S. layers, then we have to consider the residence country layers of what tax problems, kind of reproportioning things might involve.
Right.
Ahead of time,
Absolutely.
right? So there's no clear solution that's going to work in every circumstance. Is what
Yes.
I'm getting at.
Yeah, absolutely. I think it's fair to say. And so just to summarize, the validity of the will is an important consideration. Planning ahead to ensure that you are prepared for the possibility that there may be delays in the distribution of your estate, including things having to do with a transfer certificate. Make sure that the planning considerations include things like, do I need one will? Do I need two wills? Where, in what jurisdiction should the will be established? Stan, you brought up a good point. If there are going to be delays, are there things you can do in terms of liquidity, ensuring that a certain spouse has enough liquidity? There could be things involving life insurance as well that could be part of that strategy. Now, we're almost out of time. We could just keep talking about this stuff for hours, but we do need to wrap it up. But before we do, there is one last topic I wanted to touch on. And if we go back to my earlier example of someone who maybe had a will established, 20 years ago in the US and has since moved abroad, what we often find is that the will is going to have, some sort of trust component within it, or, that part of the estate planning strategy will have involved a trust. Now, as a practitioner working with cross-border families, what are some of the potential issues that you see there and things that may concern you?
Well, unfortunately, we've experienced this a number of times. So let's go back for just a moment to the common law countries and the civil law countries. Common law countries like the US, we often use trusts in our wills, right? That will come about after the death of the decedent, that would maybe provide for the spouse or the children or children from a first marriage. And we often use revocable trusts here in the US. And in many or most of the civil law countries, they don't recognize trusts. And in fact, they punitively tax them. I mean, it can turn out to be a real disaster before you die, as well as after you die. And so, though that kind of planning needs to be really critically examined and talked out, thought through, and coordinated with a trust and estate person in the other country to make sure that we're not running afoul of those rules and laws. I've had a number of clients who have moved out of the US who made revocable trusts, which was the perfect planning in their state in the US to avoid probate and other situations. They moved out of the country And then those trusts were really hit with huge income tax consequences. One recently, she paid well over $50,000 in Canadian income tax because she had this revocable trust running. Canada doesn't recognize them. They treat it as a separate entity, not as a flow through. So, it is a very large concern.
I find it ironic that you've pointed out that the civil law countries don't recognize trust, but then you use Canada as an example. So even in another common law country,
exactly,
a U.S. trust may not work as designed, to say the least.
Absolutely, and
exactly right.
Yeah,
and I've got a real life civil law country example. Actually, the planning was for parents who live in New York City. They wanted to use a revocable trust to avoid probate in Manhattan. That would be prototypical planning for us. But they have a daughter who lives in France and married a Frenchman and has children in France. And she is a French tax resident. And France doesn't recognize revocable trusts or really trusts at all. And in fact, the French tax laws impose a filing and reporting requirement on the U.S. citizen if that trust has a French tax resident beneficiary like the daughter. And so, we looked at it very closely. It would have imposed a huge burden and expense, even though my clients are domiciled here, resident here. They have no contact with France except that their daughter lives there. And so, we made other arrangements to split their estate to their daughter and their son in the U.S. We provided her with benefits under the regular U.S. will, right, that were not inside a trust. And so we were able to equalize them in a different way. But that's just one example. So trusts need to be really looked at if people are moving to any other country than the U.S., as you pointed out, Stan.
Yeah, that's a fantastic example of it's not just your estate planning. If you live abroad and you're expecting, and you still have relatives that might leave money to you, it's their estate planning that could have unintended consequences.
And the French example is interesting as well, because technically you could be a beneficiary of a trust and not even be aware of it. So you could not even know about it and still technically be in violations of those reporting requirements. So,
France doesn't care if you're in technical violation or not. They're going to tax it.
Right. Violation is a violation, exactly. So as Stan reminded me, very often is trusts don't travel well. So if you are going to use trusts as part of your estate plan, then be sure to speak to professionals. So
I had one other example, if we have just a minute.
Sure. Please.
And it goes to the citizenship, domicile, residency example, and a real life example. So we had a client who approached us a year and a half, 2 years ago, and she is from Chile. And she had moved to New York City, had a young daughter, bought a condominium there. And while she was there, she had U.S. tax advice and trust and estate advice. They put it into a revocable trust so that it wouldn't be subject to probate. While she lived here, non-U.S. residents, actually resident here in the U.S., are entitled to the same estate tax exemption that a U.S. citizen is. So that exemption was very high. There would have been no estate tax consequences. And her attorneys told her, don't worry about it, just put it in that revocable trust. Well, she moved back to Chile without the intent to return here. And she approached us to see if everything was going to work out right, given the other advice. And so we advised her right away, look, you only have a $60,000 exemption now that you're not residing in the U.S., so we really need to do something about this. The condo was worth about $1 million at that point. And so we did develop a strategy to put it into an LLC, to transfer the LLC units into a foreign trust, and that would have alleviated the estate tax issues if the IRS didn't come back and challenge it. We didn't think they would. But unfortunately, she died before she could transfer anything. And now we're dealing with them paying 40% on the $1 million condo. They're going to pay almost $400,000 of U.S. estate tax because she didn't redo her planning in time.
Wow.
Terrible, tragic story.
Yeah.
Well, and I think it does speak anytime, and whether you're domestic or an expat, anytime there's a change of life situation, it really makes sense to go back and reconfigure your trust and look at all of that, or reconfigure your will anytime there's a change of life plan. Far too often people do a will when, their kids are minors and never update it. And, we've seen the tax law change and, likely change again. And so anytime there's kind of this major change in life circumstances, kids have grandkids, it makes a lot of sense to go and speak to the people that helped you in the first place, or an expert that can deal with these new complications. Because I think far too often people set it and forget it, with a will, because it is my last will and testament. There's something very formal about all of that, and I think people tend to forget that. As life changes, their estate plan needs to change with it.
Yeah, and this isn't. I think there's always a perception out there that this is the stuff we're talking about, and the need to get legal advice is something that's limited to this ultra high net worth, crowd. But when you're an expat, not only do you need a lawyer, you need two. You need it, and not only do you need an estate an estate planning attorney in the United States, you need one that has experience like David has working with international situations, because that Manhattan example that he gave of the default rev trust is something that 99% of the estate planning attorneys are going to do without hesitating to think of, well, what if, she moves back to Chile, right? I mean, they're not used to dealing with the uniqueness that this cross-border world, legal problems, tax problems, they're not equipped to deal with it. And you also can't get around the need to have boots on the ground legal advice in your country of residence, because only they are going to truly understand all of the nuances and the mechanisms of how it really actually works with the distribution of wealth and the potential inheritance and gift taxes of your estate plan.
Absolutely.
Well, and I think they're also up to date on what's changing constantly. And so I know one of the responsibilities of a good estate attorney in the U.S. is to reach out when tax laws change here, or estate or probate laws change here, and one would hope the same would be true for a good probate estate attorney in your country of residence. Yeah. We've gone on for a while here, David had, and I'm sure we could.
The last thing I'll say is that in particular, couples with mixed citizenships, really need this kind of help, because the laws of the U.S. may not apply to one of the spouses, but they may apply to the other. So in those situations, you really want to make sure that we're doing it right.
Another great point.
Absolutely. Well, with that, we do need to end the podcast. Our marketing team is going. So I think that's a pretty clear sign that it's time to wrap it up. And David, thank you so much for being so generous with your time. And we really appreciate you sharing your thoughts and your experience with us this morning. Obviously, these are very complex questions, so hopefully this was a good introduction to the topic. And if you have questions, feel free to reach out to us. Feel free to reach out to David. Feel free to reach out to your family lawyer, and make sure you get the right advice, and make sure that you are prepared and have the right estate plan in place. With that, we'll call it a day, and thank you for listening to another episode of Give Me Some Truth International, and we will see you next time for the next episode.
Like and subscribe.
Thanks, everybody.
Thank you, David.
David.
Walkner Condon Financial Advisors is a registered investment advisor with the SEC. Registration with the SEC does not imply a certain level of skill or training. The opinions expressed by the participants of this podcast are their own and do not reflect the opinions of Walkner Condon Financial Advisors. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Investments involve risk and, unless otherwise stated, are not guaranteed. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for any individual. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Thanks for listening, and for further information, please visit walknercondon.com.